Thanks very much, James. I don't think my talk is going to be anything as exciting as the last speaker, who certainly, I think, gave us all a lot to think about. When James first asked me to speak at this conference, firstly, I was obviously very pleased to be back here again, because I was here 2 years ago, and it's great to see that it's still continuing. But I suppose my dilemma was, what did I talk to everybody about when I was talking about the legal implications of it? Thanks. When I was to talk about the legal implications. And frankly, I probably could have covered 2 days on just talking about the legal implications alone. So I've tried to limit myself, I suppose, to various things. So apologies to some of you where I may be talking about things that you're all terribly familiar with. But I'm conscious, I suppose, I have to provide a talk that's suitable to many. And I suppose the first thing when I started to prepare this paper that I started to think about is what do I, as a legal practitioner, understand by open innovation model? And I suppose I was somewhat relieved this morning when Bernie started to speak and gave her definition of open innovation, which wasn't a million miles away from my one. So it's always reassuring to know people are thinking in the same direction. And I suppose for me, it's a business, rather than trying to do everything in-house, the research, the product development, the manufacturing, the sales, that essentially it moves out of itself. It looks to sourcing knowledge externally and cooperating with other entities, whether that be other companies, other universities, organisations providing R&D facilities, or research services. So for me it involves the exchange of ideas and knowledge and technology. And I suppose one thing that I would say, and again it may be relevant to some of you and not to others, is let's not confuse open innovation with open source. Open source is something I come across quite frequently, and it's usually in the context of technology, and it tends to cover making technology available, free, subject to certain restrictions. Open innovation is obviously a totally different type of concept, which is about collaboration, and it normally involves exchange, but exchange for value. So again, it's just, I think it's always useful to make sure we're all talking about the same thing and nobody is confused by definitions. So as I say, the purpose of me being here today was to address briefly what are the legal considerations that arise in the context of innovation. And obviously, because of my background, I'm going to be particularly focusing on intellectual property. And I suppose I would say that for two reasons. In that, firstly, I think to have this open innovation and to collaborate, you probably need intellectual property of some sort in the first instance. And normally, intellectual property is one of the results or one of the byproducts of open innovation. So I think it's important at the start of the process, and it's usually also the outcome of the process as well. Once you have intellectual property, whether it's before or after intellectual property, that immediately raises the issues of ownership of that intellectual property and how you best protect it. Now, I suppose I'll come on in a minute to intellectual property itself and what we mean by it, but you know, to sort of start from the end, so to speak, I'm going to look firstly as to why would you bother protecting intellectual property, and to just, I suppose, concentrate our reasons for that. And there's many reasons. I suppose the first thing is it's a very valuable asset. It's capable of being valued, it's capable of being included in your accounts as an asset of your business. And I suppose people have started to focus more on that now in the current economic climate, when other assets that a business may have are decreasing in value. Think of something like real property. In addition to that, you have many companies who have little or no assets other than their intellectual property. And I suppose we all think about, I suppose, the more recent companies or companies that have emerged in the last 10 or 20 years. And if you think of somebody like Apple, for example, most of its asset base would be based on its intellectual property. But go back even further, go back you know, to a company that's over a century old, Coca-Cola. Its main asset base is its IP. So IP can be a very important asset of a business. So if it is an asset, what does that mean for you? Well, I suppose one of the things that it means is that it can be used to raise finance. And again, I suppose if you want to take innovation and open innovation in a very broad sense, most businesses need to raise finance from somewhere, whether it's from banks, from venture capitalists or from other sources in order to further their business. And IP is one of the things that can help you do that. Again, as an asset of your business, you can exploit it in many ways. Obviously, the most obvious way to do it is as part of your day-to-day business. But again, and I think this is probably the key to open innovation, is what else can you do with it, as well as exploiting it yourself in the sense of using it. And that's where I think open innovation comes in terms of licensing it or selling it to other parties, or indeed being the recipient of a license or a sale from somebody else. So I think that's one of the key reasons why you would protect. There are others as well. I suppose it's the thing, if you've got IP, it may be one of the things that sets your business apart from the business of your competitors. Again, I suppose, some immediate examples come from the technology centre, and again, I'll refer to somebody like Apple, but also Microsoft, Intel. What sets them apart, I suppose, is the IP that they have, which perhaps a lot of their competitors don't have. And it does give them a monopoly for a period of time. So that's another value of IP. And I suppose, sorry, I'll just move back one more. Taking it, I suppose, from the point of view of the customer as well, it gives the customer something new and something different. And at the end of the day, all businesses need customers. Again, if I can take Apple as an example, before Apple and the iPhone and the iPad existed, there was no such thing as a business in developing apps. Now there are many, many companies throughout the world whose sole business is developing apps. So we can see how IP can lead to totally new area of business for somebody. One other thing that IP can be used for, and I suppose you could regard this as the exact polar opposite of open innovation, and that's to use your IP as a defensive strategy, i.e. simply to prevent other people doing something, whether that's having a patent for the purposes, not of you exploiting it or making any money out of it yourself, but simply to stop other people exploiting that particular invention. And as I say, I would see that as the exact opposite of something like open innovation. The final thing that I would say as to why you should protect IP is that it'll be easier for you to enforce it if anybody starts to exploit it without your permission. And I'll come on to that in a little bit more detail later on in this talk. But as I say, there's many reasons if you have IP why you should look after it in the same way you'd look after any other asset. Now again, I'm sure you all know, but just to recap, from everybody's point of view, what exactly do we mean by IP? And obviously I'll be focusing a lot today on things like inventions and patents, but it isn't just inventions and patents. There are many other things that you can create, whether you're a business, whether you're a university, that may result in IP. Other examples of IP, which I've listed up there, are brands, logos, domain names, trading names. There's also fixed work such as books, articles, brochures, marketing. I mean, for example, to take a few examples, if you're, for example, a drug company, obviously your drug involves IP, but so does all the materials that go with it that have been created. The copyright exists in those. But as I say, one of the things today I'll be focusing on are innovations and patents, because I suppose that's the thing we come across more frequently in the context of open innovation. Another example, though, that I've up there as well, that people sometimes tend to forget, for any of you who are involved in the development of actual products, shapes of products may in themselves constitute IP that can be protected, and I'll touch on that later when I talk about design rights as well. So let's assume you've decided you have IP, you're convinced by the reasons that you should protect it. How do you actually go about protecting it? Well, I suppose the first thing is there are various registration options open to you, which I'll touch on briefly, and where they are possible, and assuming your budgets allow it, clearly you should try and register your IP. I'll also outline some practical ways that you can protect your IP. Obviously then the main way of protecting it is by actually exploiting it, actually using it and making money out of it. And then finally, by defending it if others exploit it without your permission. So let's have a look at a little bit more detail at the different areas of IP. And how they can interact, I suppose, with open innovation. And I suppose firstly I'll touch briefly on patents, because that's probably what most of you come across more frequently or are more familiar with. And when we talk about patents, we're talking about protecting inventions, essentially. Obviously, patents are territorial and laws differ from country to country. But in general, if you're successful in getting a patent, it's normally for a period of up to 20 years. Before we talk any more about patents, there's one thing I just want to emphasise, which can sometimes, I suppose, lead businesses into problems and can cause problems down the road then if you're trying to exploit your IP, is it is quite important before you apply to register a patent that you do carry out some searches. And I suppose I would advise clients to do that for two reasons. Firstly, if you're making a patent application, you want to make sure that there isn't something in there before you that may prevent your invention from becoming registered as a patent. But secondly, to make sure you find out who else might be in there before you, who might sue you for infringement, so that you don't end up spending a huge amount of money on something and then suddenly discover that you're being sued. Another thing which I think is actually quite important in the context of open innovation, because I think one of the key ingredients of open innovation is knowledge. And I think perhaps one of the ways that businesses can get knowledge, which sometimes may be somewhat overlooked, is that there are many different companies throughout the world who provide watch services. And essentially what that involves is monitoring patent registers around the world. Now, obviously, if you have a patent registration yourself, you may be very interested in doing this because you want to make sure there isn't somebody coming up behind you, and you may feel that their patent application potentially infringes your registration and you may want to do something about it. But I think patent searching or patent, one of these watch services, can be an important research tool in itself, because it can provide you with information, firstly on what your competitors are doing and the direction they're going in, which may influence the direction you want to go in. It may also assist you in finding future partners in terms of identifying businesses with comparable or compatible products to yours. It may also help you become aware of technological breakthroughs, and all of that can be the start of finding perhaps a potential partner that you may be able to cooperate with. Another thing that I always advise people as well, inventions can change over time. You start off, you come up with a particular invention, you apply for patent protection and you forget about it then. But in the meantime, your invention has been modified or it has changed, and it may have morphed into something quite different from what it was originally. It's important that you keep an eye on your invention and go off and take advice to just make sure that you're not at a stage where you need to perhaps make a further patent application. I'll quickly look at some of the other areas of IP, because again, they also have potential to be used and shared with others in return, I suppose, for consideration. And I'll touch briefly on trademarks. Essentially, trademarks are brands, logos, sounds, smells, colours. Probably before you came here today, you've probably encountered many different brands without realising it. You would have gotten up this morning, you would have had your Kellogg's cornflakes. Kellogg's is a brand. You would have come out, you would have got into your car, whatever brand that may be, that's no doubt registered as a brand. You probably used your iPhone. We encounter so many brands every day, we forget about them. The key thing, I suppose, about a brand is that it's the way that goods or services or a corporate identity is represented. And it is a badge of origin for the consumer. You buy a particular brand because you associate it with a particular level of quality. So brands are important to a business, and they can be protected, I suppose, in two ways. In one sense, you can just leave them there and not do anything in particular about them. And there is an action, which is called an action for passing off, which you can bring if you find somebody else is using your brand. I suppose from my point of view, it is a more difficult action to bring, in the sense that you have to be able to show that the brand owner has reputation in that particular brand, and that's something that needs to be acquired over time. There is, however, a registration system where you can register a trademark, and it is much easier and simpler, and at the end of the day cheaper to enforce. Again, I would always advise that before you embark on coming up with a particular brand for your business or for your product, that you do carry out searches to make sure there's nobody there before you, so that you don't find yourself on the receiving end of an infringement action. Again, it's also important as well that you keep an eye on your brand, particularly if you use logos. You will find variations creep in over time, and you suddenly look at the logo at one point in time and it's changed radically from what it was when it was first developed. And that may mean then that you're not actually using the mark in the form in which you registered it, which may mean that your mark may no longer be valid. Now, sorry, I should have moved on a bit there. Again, trademarks are I suppose, somewhat different from patents in that when you have a trademark, you register it in respect of particular goods or services. So if you take the example of Mercedes, they will have it registered for cars and car parts. They won't have it registered for cosmetics. So you need to make sure that businesses develop over time, businesses develop different products. You need to constantly keep looking at your trademarks and make sure it covers all the goods that you use. Company names. Sometimes clients can be somewhat confused. They think that because they've got a company with a particular name, that somehow gives them protection as a brand. I mean, a company name doesn't really. It just means that you have a company with that particular name. It doesn't of itself give you any particular rights in that name. Domain names can also be important IP rights. If you do have a particular brand, you should probably try and register that as a domain name as well. Lots of people just simply use the .com, depending on what way you operate your business. You may also prefer to have the country designations like .ie or .co.uk. Now, I mentioned earlier that if your business involves products, you may have design rights in your products, because a design right is something that protects the physical appearance of items. So that can be anything from, for example, the shape of a lamp to a pattern or a textile. It is, I suppose, a bit of a Cinderella of the IP rights, in that not many people necessarily know about it or utilise it. It comes in two forms. There's an unregistered right, which arises by virtue of having created a design. That tends to be used a lot by, for example, the fashion industry or the jewellery industry, where they have a large number of products coming onto the market at any one time, but those products have a particularly short life, so they don't necessarily want to incur the costs of trying to get registered protection. I suppose the downside of that is the right only lasts for 3 years, but sometimes if you think of it in something like the fashion industry, that may be more than adequate. Registered rights last for much longer. They have the potential to last for up to 25 years, but you must keep renewing every 5 years. Copyright. I mentioned there earlier that, for example, if you're a drug company and you produce literature to go with your particular product, you may have copyright in that text. Copyright, I suppose, is somewhat different from all of the other rights that I've just outlined, in that it doesn't arise by registration. You don't formally apply to anybody to get copyright. Copyright comes into existence the minute the work in question comes into existence. That can sometimes cause a problem for people like me, because a client comes along, they want to enforce their copyright against somebody, and I've got to establish proof as to when the copyright was created in the first place. There are many things, I suppose, that a business can do. You'll see down at the bottom of my slide, I have the little c in brackets, I have my name, I have the date I created the slides, and I'm saying that all rights are reserved. That means there is physical proof that I created this in June 2012. The other thing that you can do is, which clients sometimes do, is they'll deposit a copy of something with me. So if it may be a source code for a piece of software, it could be a book, whatever it is that they're claiming copyright in. I will then have a record of when I received it, and if there's ever any doubt as to when it was created, I can be called in evidence to prove when I got it. The other old trick is to post it to yourself, but please make sure you do not open the envelope, because the whole idea of posting it is you have an envelope which is sealed with a franking stamp on it, but people do open it, so that sort of defeats the purpose. Okay, I mentioned earlier that IP rights are territorial, particularly registered rights. That's not 100% the case. There are some exceptions to it, but I'm, I suppose, emphasising this particular point because it is important when you are engaging in any activity in relation to your IP that you're very conscious of the territories in which you may require protection, and don't assume that just because you've got protection in one country that's going to extend to anywhere else. That isn't the case. So we've talked about intellectual property, we've talked about how you protect it. Assuming you've done that, you're part of the way there for being able to use your IP for commercial purposes. But I did say that I'd also emphasise some practical ways that you can protect your IP. And I suppose these are items, I suppose, that over the years and advising various clients and I suppose seeing where things go wrong, they're sort of pointers as to, you know, if you address these things, there's a less likelihood of things going wrong. And I suppose the first area where I've often seen where things can go wrong is where a business, and in this context where I'm talking about a business, I'm including universities. I'm just using business in a generic sense to talk about any entity that creates IP. And the first thing I'd say is it's very important to have clear contracts with your employees and with your contractors. And I suppose to just explain to you who may not know what are the difference. An employee is essentially a person for whom you deduct PAYE. He's a person who would normally work and be regarded as your employee for that reason. An independent contractor tends to be somebody that you engage from time to time or on specific projects, and they would invoice you. They're responsible for their own tax. So that's a rough distinction between what they are. But it actually is quite important from a legal point of view, and it's quite important from an IP point of view, because if somebody is an employee, there's a presumption that anything that they create belongs to their employer. Now, we'd still advise that you should have a proper contract of employment that sets that out in any event. But at least if you don't have that, there is that presumption. There is not that presumption if somebody is an independent contractor. So if you bring somebody in on a specific job, if you bring in somebody in, for example, to develop a website, to create some marketing material for you, and that person creates intellectual property, unless you have a specific agreement with that person, at best what you have from that person, because you've paid them some money, is a license to use it. But you wouldn't have the right, for example, to exploit it. So that is quite important. That can cause you problems down the road if you're then trying to collaborate. Another one here is quite practical, but it can be quite important, is that you have systems in place for the recordal of information. Research notes, meetings and discussions relating to inventions or developments, have those noted in a logbook, and it doesn't matter whether that logbook is a manual one or an electronic one. If need be, have those entries witnessed and dated and make sure that they're kept in a secure place. You could even go so far as in your contracts of employment with your employees, where it's relevant to them, having an obligation on them to maintain logbooks. It just makes life so much easier if you ever have to enforce your rights in the future. Confidentiality provisions. If you have something that's confidential, it's essential if you're handing it over to a third party, you make it very clear that it is confidential, because the number of times information is handed over and people after the event say, well, you should have known that was confidential. If in doubt, just make sure whoever you're handing it over to is aware that it's confidential. Again, at common law, there would be an implied obligation that employees do have obligations of confidentiality. But again, we would always advise that you have something in your contract of employment that specifies for all employees that they should keep information confidential. I've talked to you there earlier in the context of employees about contractors, and to just make sure that you have specific contracts with them, making sure that they assign any IP that they create for you. Then in relation to security, again, these are just practical things where I've encountered over the years. If you do have confidential information, make sure it's password protected. That sounds very simple, but it's more honoured in the breach, unfortunately. If it is confidential, limit the access that you give to it. You don't have to tell everybody, just tell people on a need-to-know basis. make sure you have good antivirus software, make sure that you have good firewalls, make sure that you have regular backups, and I suppose most importantly, make sure that you have a plan if anything goes wrong. So, we've seen on the news over the last few days the various flooding in the UK. We've had it here in Ireland as well. If there's fires, etc., just make sure that you have a plan in place, because if it all goes up in smoke, it's very difficult for us to then prove that it existed. So, now that we've given you some practical ways, how do you then go about exploiting your intellectual property? And I suppose this is where the open innovation model comes in. So rather than everybody trying to do everything themselves, you then cooperate with other entities to see how you can do it together. I think this has probably become an even more important business model as society progresses, because we now, I suppose, are seeing much more complex products. We're seeing products that require multiple technologies. We're seeing products that require different levels of finance at different points in their lives. And unless you're one of the very large, very long established companies, it's going to be very difficult for you to be able to do all of those things at the one time. And that's why I think something like open innovation enables businesses to do this, because they can simply combine with others to do part of it or to do the next stage of it. I think another aspect of it, which sometimes is, I suppose, a little bit underexploited, is the value that people can extract from IP that they literally have lying around. You'll find that, I suppose, as companies grow, they develop patent portfolios. A lot of it they may not use anymore, and they seem to assume because they're not using it anymore, it ceases to have value, whereas it may be quite valuable to somebody else who can adapt it or use it in conjunction with something else, and in the meantime the owner can make money out of it. So, open innovation, some practical examples, I suppose, of the type of things that cross my desk or I would be involved in. You could have, for example, a university. It comes up with an invention, but it needs to partner with somebody to take it to the next level. It has come up with it. It doesn't have the ability to finance it. It doesn't have the ability to put that invention into production. It obviously needs to combine with a business who can take it to the next level. Likewise, you could have a business who has an idea, but to take the idea and turn it into a proper invention, it needs the resources of a university to assist with research so that it can actually develop the product further. And again, as I say, you can then have the business who has lots of patents lying around, no longer core to its area, and may want to offload them and make money out of them. Or finally, you may have somebody who has a particular product, may think, okay, that invention could perhaps be used in conjunction with something else, but they need to combine with the type of business that has the something else. So they're the sort of things that I would deal with on a day-to-day basis in terms of how to bring all of that together.